so eager to sell my company that I forget about the NDA, what can happen in that case?
The information can be misused, and that can be detrimental.
We're going to talk about the sale process today, a startup exit. And there's 5 different steps, but we're going to start with the first one, and that's the NDA. What is that?
That is the non-disclosure agreement.
Non-disclosure agreement.
Yep. So we have a match, a buyer and a seller who's interested in each other in the company. And in order for the seller to provide the buyer with the information needed, then you need to safeguard, protect that information. And that is what the NDA does. It says that we can share information with each other and you may not misuse that information.
But what kind of information can it be?
Good question. Everything that has a value or that proves that your company has a value. So it can be innovations, research and development, your employment agreements, your marketing plan, your price strategy, the agreements with your customers, everything that is super sensitive and that if a competitor gets a hold of it, they might misuse.
Okay, so that's what you want to save up, the information.
Yeah, in order to share it between each other, you want to safeguard that information. So you cannot use it for any other reason than to evaluate the deal.
So this you have to do quite early, because if I want to sell my company, you need to start with this one, right?
Yeah. Typically, this is the first step, the first agreement, and it's quite short. 2 pages will be enough. And even me as a lawyer can say that you can find a standard online. It's not that complex. Just be mindful that you have a carve out so that information that you already had and known will not be covered. Information that you have to give to authority will not be covered. You're allowed to share the information with an advisor, a lawyer, financial advisor. And also watch out for liquidated damages that are way too high. And check how long will the information be protected.
Okay, so you need to be specific.
Yeah.
But what if I'm so eager to sell my company that I forget about the NDA? What can happen in that case?
The information can be misused.
Okay.
And that can be detrimental. Of course, you're still not allowed to steal business secrets from each other, but you do not have that fundamental protection.
Okay, that's why it's really important to have the NDA.
Yeah. And of course, you should also know that it's quite hard to, 2 years later, if you on the market see a competitor doing something and you suspect they have for some reason gotten a hold of your information, it's extremely hard to prove. But still, having the NDA in place will provide a fundamental protection for you.
So you can get a small chance to maybe...
Yeah, and hopefully people will get deterred so they will not try to misuse it.
Okay. Thank you so much. I got it clear. I understand. And if you have any questions regarding this or other things that concerns the business law, don't hesitate to put them down below and subscribe and like our channel. And we'll be back very soon. Thank you so much.
Another binding part is the exclusivity that the buyer will want to have from the seller. The buyer will want the seller to promise that you will not talk to other buyers.
We are going to talk about the sales exit, and we have started to talk about the 5 steps when you are selling your company. In the last episode, we talked about the NDA, which was the
non-disclosure agreement.
Non-disclosure agreement. And today we're going to go to step 2, which is the term sheet. And that is a bit tricky.
It is. I know what you're thinking, because that is a non-binding agreement between the buyer and the seller that outlines the major clauses, terms and conditions of the deal. And it has some parts that are binding. So that's the tricky part, right?
Yes, because in my world, either you're binding or non-binding. There's no in between.
So the purpose of the agreement is to outline the non-binding, like the price. And this is before the buyer knows that much about the business. So that's why it will not be non-binding. We agree that if we do the deal, these will be the typical terms. Because if you don't see eye to eye on the major issues, you should not go through because it's costly to buy and sell a company. So this kind of checking out if we have kind of a deal to be made. And in order to kind of get this whole thing structured, we have the binding parts. And one of the binding parts is that we say that we agree that nothing will be binding until the final agreement.
Yes.
So we have that in writing. Then you cannot hold me liable for anything until we sign the final agreement.
Okay, so that was the binding part.
One of the binding parts. And another binding part is the exclusivity that the buyer will want to have from the seller. The buyer will want the seller to promise that you will not talk to other buyers.
Okay, so is it always these two that are the non-binding on the binding?
No, it can differ. You as a seller can say, no way, I'm going to go out for auction. I'm going to offer my business to everybody. So it's up to you to accept. But if you're approached by a bigger buyer, you most likely will be quite eager to agree. But you should be mindful, because if you can find other buyers, check the market before you sign. And also be mindful for how long is the exclusivity. It should be short.
It should be short. Why?
So you can shop around. And for you as a buyer, it should be long. Because then you can push, and the seller has nowhere else to turn than to you.
Okay, so when you are signing the term sheet about the binding parts, is it only you two, the seller and the buyer, that agrees what should be the binding parts?
Absolutely, it's a contractual.
Okay.
So you can come up with a completely different solution. You can also have what's called a breakup fee, which we discussed in a specific episode. But that says that what is to happen if we never sign the deal, and both of us have put so much time and effort and monies into the negotiations and the preparations, who shall bear the costs? So there can be other terms and conditions that are binding in the term sheet. It's really up to you. So read it carefully. That's my best advice.
That's your best advice. So this, you could see it as like the pre-buying or the pre-agreement for how the affair is going to be, or what?
Yeah, and that's also a good part, that an experienced buyer will expect the non-binding parts to be transferred into the final agreement. So, as a seller, make sure you agree. Don't sign if you are not in agreement, if you're not willing to accept them at the end.
Okay, so if it's the first time for me signing a term sheet and selling my company, what is the most common mistake?
To sign a too long exclusivity without realizing the implications.
That can be a risk. So you get held in that situation.
Yeah, because basically your bargaining position is the strongest before you accepted the term sheet with a given price that can be reduced if the buyer finds issues or you don't agree to specific reps and warranties, and you sign the exclusivity. So before the buyer has you, you are more free to negotiate than later on.
So read through carefully.
Yeah.
And that was the term sheet part.
The term sheet. Step number 2.
Thank you. And if you have any more questions about this, don't hesitate to drop them down below here in the comment section. Thank you so much, and don't forget to subscribe and like the channel.
It is kind of uncomfortable. You get kind of stressed out. If you don't want a big lawsuit on your hands afterwards, I mean, you want to keep the money you're getting, right?
And we are back to Business Law Toolbox. In this episode, we're going to keep on talking about the 5 steps when selling your company, the M&A process. And we're heading out to step 3, which is the due diligence.
Yeah.
The most important part, I guess.
Well,
if you want to know everything about the company.
Yeah. So the due diligence, we have number 1, the NDA, right?
Yes.
About sharing information. And then we have number 2.
Which is the term sheet.
Exactly. The non-binding, about the general terms and conditions about, so we're kind of in agreement.
Yes.
We kind of have a direction.
But some parts were binding, which we are talking about in the previous episode.
That we will link to.
Yes, of course.
Perfect. And now, when we have that general agreement, I, as a buyer, will want to know everything about the company.
Like everything.
Everything. And that goes back to the principle caveat emptor. And that means buyer beware.
Okay.
Because you're buying the company at your own risk. So if you're buying that company and you do not know that it has tax liabilities or a big lawsuit or something like that, it will be your responsibility.
Okay, so buyer beware is when you take the risk as a buyer and everything that comes with the company stays on you.
Pretty much.
Okay.
I mean, not if it's been fraudulent or something like that, but basically, like if you're buying an old car, you want to kick the tires.
Yeah.
And that's the due diligence.
So, what is the first thing you should think about when doing a due diligence? What do you want to know? I mean, exactly.
Yeah, typically you divide it into 3 major parts, which is the financial, the legal, and the commercial. And apart from that, you can do millions of due diligence. Okay. You can do environmental, IT security due diligence, whatever you can come up with. Okay. But those are the 3 major.
Like the most common parts.
Yeah. And as a seller of the company, it is kind of uncomfortable.
Yeah, I can imagine. I mean, you need to open up all the books.
You get kind of stressed out. And if you're a first-time entrepreneur starting your first business, you will have all of the focus on getting it running, making it profitable, attractive, getting the everyday things working. Mm-hmm. So you might not have had the time and the energy to think of all the legal aspects or the record keeping of the finance, everything like that, like in perfect order. And all of that will come up to the surface during the due diligence. Mm-hmm. So typically, it's kind of uncomfortable for you as a seller of the company.
Yeah, and how do you handle that? I mean, you cannot hide anything. Even if you don't want to hide anything, because I think maybe it's better to be transparent. But the financial part, let's say if there was something bad that happened, you need to tell your buyer.
Absolutely, because if you don't want a big lawsuit on your hands afterwards, I mean, you want to keep the money you're getting, right?
Of course.
Yeah, then you need to be transparent, because everything you have disclosed and really shown the buyer will be things that are considered to be priced in. So the buyer can't say, oh, I didn't know about this lawsuit, if you're being completely transparent with it. And what you should really, really, really know also, I've been doing this for 15 years. I've never seen a perfect company.
That's good to know.
Yeah. All companies have messed up in some area or some issue, some problem, or some documentation missing. So what you really, really need to do is, like you said, be transparent. Because the biggest turnoff for a buyer, in my experience, will be when somebody does not tell. Because then you get really worried. Okay, so I had to find out this all by myself by putting my legal dogs on you. Then what else will you be hiding from me?
Yeah, and then you talk about other things that you cannot trust the person.
Exactly.
Or something. But you said the word pricing in.
Yeah.
Can you just explain it? What is it?
Yeah, good question. So everything that I know, everything you have shown me and told me about the company, if I start complaining after I have bought company, I've gotten the keys from you, and then I turn to you and say, you know what? The tax authorities are on me for this and that. Well, if you already informed me about that, then I cannot come and blame you for it, because I knew about it, right? But if you kept quiet or even tried to hide it, then I might be able to come after you. And we'll discuss the reps and warranties in the next segment when we talk about the share purchase agreement. And that's super tightly connected to the due diligence, because you will need to promise that everything that you have not shown me is okay, is in order. There are no other issues that I should know about. So that's why it is so important to be transparent, and for you as a buyer to really be careful and do your responsible due diligence.
So, I mean, if you're talking about pricing in, does that affect the final price at on the company?
Absolutely.
So if I did something or missed out or have taxes or anything, it needs to be priced in.
Yeah, or it can be in a specific indemnification, which also we'll get into in the next episode, step 4. But that basically says that if I identify a specific risk or issue, a lawsuit, for example, then you can promise that if that happens after I have taken over the company, you will reimburse me. You will pay me for it.
Okay.
Typically, you talk about my watch, your watch. So everything that happens before closing is on your watch.
Okay.
And that's
as a seller.
Yeah. But if you've been transparent again, then I already knew about it. Then I'm buying into it.
Okay. That's good to know.
Yeah. So due diligence, super important and very tightly connected to the share purchase agreement and the responsibility you take on.
Okay. So what about, that was about the financial part.
And the legal.
But what's the most common mistake people do when doing this?
From the buyer or seller?
We'll start with the seller.
Seller. Not being ready for it. When we talk about small, medium-sized company. Because the best thing you can do is do a vendor due diligence, your own due diligence, and try to get your books and records in order.
Yeah.
I mean, imagine you're selling your house. The buyer will most likely be okay with you having some kind of dirty laundry. I mean, it's reasonable. You live in the house.
Yeah.
But if he comes in and the first time he's going to look at the house, you have your dirty laundry all over the floor, he will start to wonder, and he will have a hard time seeing the beauty of the house, and he will start to wonder a bit about if you're bringing your A game, really. So do your homework first and fix whatever problems that are fixable before you go to the buyer.
Okay, so that's like the vendor due diligence.
Yeah.
You do it by yourself first.
Yeah.
And then also that can make you more ready to do the due diligence.
Or even if you come with a proper vendor due diligence, the buyer might say, I don't need to do due diligence. As long as your lawyers and your finance people state that they do the due diligence as if they did it for the buyer. So that they're not kind of doing a selling, but instead doing a proper due diligence. Then the buyer might only want to do a confirmatory due diligence, picking some specific agreements that he wants to look at, some things only.
Okay, so it can be very uncomfortable, which I understand.
Yeah.
I mean, you have to open up everything and it comes to you at the end.
Yeah.
As well.
And my best recommendation for you as a business owner, keep your head cool. Because what can also happen is that when the buyer, he gets this brilliant lawyer and brilliant finance and a brilliant team looking at the commercial, all of them will cost a lot of money, which means that all of them will want to prove that they're worth the money, which means that all of them will want to ask a lot of questions. They want to do findings, and that can be crazy frustrating as a seller. I mean, it can take time, it can get annoying, it can become, don't call my baby ugly, prestige, and that's not a good way to get your company sold.
But that's heading to like the emotional part of it, because you need, as you said, you need to be prepared.
Yeah.
Because it's very hard. It's your baby, and if someone come and ask question, I mean, I would feel defeated and maybe very, very uncomfortable.
And even worse, somebody comes and asks you for this information, and then somebody else comes and asks you for the same information.
Yes.
And then a third party is calling you baby ugly. I mean, and you're trying at the same time. I mean, you need to run your business, right?
Yes, exactly.
Extremely time consuming and takes a lot of energy. So if you're already prepared and know the situation, it will be easier. You will know that this can happen. It will be normal. Then I need to talk to the buyer. We need to discuss the process, the timeline, what kind of resources you can provide and when. And then you can manage it much better and also impress the buyer. So the buyer will want to buy your company even more eagerly. So the win-win.
So it's better to be honest and transparent.
Yeah.
Much better. Thank you.
That you claim that we did,
Mhm.
I will come after you.
That you don't agree with each other afterwards. I mean, how do you handle that? And we are back with a new episode. We're talking about business law as usual, and we have our business lawyer, Kat, here with us today. And she is here to tell us everything we need to know because the business world can be complicated, as we know. So that's why we are doing this. And we are talked about earlier about the 5 steps when selling a company. We talked about step number 1, which was the NDA, and the full name of that was the
non-disclosure agreement.
The non-disclosure
about information sharing.
Exactly. Number 2, it was the term sheet.
Yeah.
Number 3, it was the big part with the due diligence, like the audience of the company.
The audit, yes.
And today we're going to talk about step 4, which is the share purchase agreement. And this is now we're going to sign the papers.
Time to celebrate.
Time to celebrate.
Yay.
So what's happening now? We went through the due diligence, and now we're going to sign the paper. We agreed on everything.
Exactly. So it's a final agreement. And up until this point, it's enormously stressful for the seller because you're not sure, you don't know, right? So it's a huge, huge, huge milestone. And typically, during the due diligence, there will be fierce negotiations about the SPA, the share purchase agreement, because they will interact. If the buyer finds something, he will want that covered in some form in the SPA. So it will be a long contract, it will be complex, and it will have meaning. It will be important. It won't just be boilerplate. So, I mean, you want to sleep at night, right? Not being worried that you have to pay back those cash monies that you got.
No, or a lawsuit or anything that can happen.
Exactly. So that's why we want to be mindful of what we put and what we accept in the SPA. So if we're going to take it top to bottom, the major points that you need to be mindful of.
Yeah. How do we begin?
Yeah. Well, firstly, it defines the company, the shares, who's the seller, the buyer, and everything. But then we'll also have the price, and we'll talk about how and when you will get that price. And that can be kind of surprising to some sellers, first-time sellers, that typically you will not get all of the cash at once.
Okay.
It will not be at closing when you give the keys and you can just take the monies and drink champagne.
Okay, why is that? I mean,
because most buyers will want to give it in tranches, like in portions, because they want to make sure that they are buying a solid company and that there are no issues. So they might say that you get, if you're selling the company for 25 million, they might say you get 10 million upon closing, but then you'll have to wait a whole year before you get another 10 million, and then another year before you get 5 million.
Okay, so this is like a risk safety for the buyer. Is it a common way of doing like this?
Very, very common. And it can even be that they want to put the monies in an escrow account, a third party holding it. But that's even better for you, because then it's not in the control of the buyer, it's control of a third party. But either way, you should expect that they will not want to pay you all cash up front. And that can be also if you have more than one buyer, perhaps it's even more important for you to know that you get all of the cash right now than to get the highest price. So that might affect which buyer you're going to start negotiating with and sign the term sheet with.
And this agreement about the payment must be in the SPA, the share purchase agreement.
Yeah, it will be regulated in the SPA.
So no misunderstandings will happen, because if I sold the company, I think I would assume that I got the money the same day I gave the keys.
Yeah. So typically at least the savvy buyer will not want to pay you everything up front or have some kind of security issue. It can be also that they want the earnout, that part of the price will be dependent on the performance of the company.
After the selling process?
Yeah, exactly. And we can have a specific episode about that.
Yeah, sounds very interesting.
Yeah. And also, what should we more talk about with the price? It's the price mechanism. So, the price you decide will be based on accounting that is historical, right?
Okay, tell me a bit more about it.
Which means that the historic accounts might say that the company is worth 25 million. But what if between the historic accounts signing and closing, you decide to sell assets worth 10 million from the company, and you might then pay dividends to yourself for 10 million.
Between the agreement and the closing?
Yeah.
You mean that? Okay.
Yeah. So then you need to regulate that. So some kind of pricing mechanism that if something happens between the historic accounts and the closing. So you need to look at that also. It can be a locked box, which is you decide prior and you only adjust for leakage. Or it can be a completion account, whereas when the buyer has control over the company, the buyer will be the one setting up the final accounts and doing the price adjustment.
Okay, but doesn't that sound like a bit risky? Because if I'm selling a company, I mean, or if I'm buying a company, I want to know how much to pay for it.
Well, yeah, kind of. I would say the completion accounts is probably more risky for you as the seller.
Yeah.
Because then you're not in control over the calculations and documentation that's kind of built up to the price adjustment. And it can be a significant price adjustment. So you need to be mindful. You need to make sure that you have the right to audit the accounts. And you need to make sure that there's a good dispute mechanism. So if you can't agree, instead of you needing to bring a full-on lawsuit, you typically have one of the big accounting firms, an expert, kind of independent third party, reviewing it and making an assessment for you. So that can be regulated in the contract.
Okay, but is it common that it can be price discussions that you don't agree with each other afterwards? I mean, how do you handle that? Because if I listen to this now, I'll be like, no, I don't want to sell my company if it's like this.
No, and I would say that the earnout, you even say that you agree to fight about the price later.
Okay.
They typically end up, no, not typically, but
it's common.
Yeah, it is. So you need to be mindful of that. And again, that might be enough for you to accept the lower price instead and feel that you get the cash up front or feel that you know what you're getting. So you need to be kind of think it through. And the early on you hear when we talk about these discussions, you can kind of start and progress and kind of what's important, how can I navigate this? So it's good information to have early on in your selling your company journey.
Yeah, so of what I can hear now, you can negotiate about everything. If you have a good relationship with the buyer, if I'm the seller, you can negotiate how you want the deal to be. So, I mean, do you need to be very specific from the beginning?
Yeah, and what I can say, that's a good point, because often also a buyer, it's a bit depending on if it's a strategic buyer or a financial buyer, but we can skip that right now. They might want you to stick around also.
For a bit after the closing or the agreement? Okay.
Yeah. So that can be one of the conditions that you stay on for 3 years, so you don't just pick up and leave. So you need to be ready also. If you're a key player, they might say that we'll buy it, but only if you stay around for a while.
Okay. And that's also in the agreement?
Yeah.
Perfect.
And if we're going to skip ahead to the major points that you need to think about, there will be conditions precedent, which are things that need to happen before the deal, before the closing, before the actual transaction happens.
Okay.
So even if you sign, you're not home free.
Okay, tell me more about that.
Because the buyer might say, okay, I'll buy, but only if you take care of this issue, or only if you sign a new employment agreement with me, or only if we get a okay from a specific authority that needs to give us okay. And if that hasn't happened for 6 months, the deal is off.
Oh.
no 25 million. It's gone.
Okay, so it can be based on like other things. So let's say, the company has to make 2 millions in 2 months or something. Can it be like that?
It can be a performance, but typically it's more like something that should happen.
Okay.
It might be, I might say that, okay, but only if you sell off that real estate, because I don't want to buy that part. It's environmental issues and things, I don't want it. And if you haven't sold that at that date, then I don't want to buy it. Or if the competition authority says no, well, then we can't go through with the deal. So as a seller, I would say you want to keep it as short, as few conditions as possible, really, to feel kind of safe that the deal will happen, and also that the deal won't take too long to happen.
Yeah, that can also be a thing. I mean, do you need to decide for the time frame for everything to happen? Because maybe if there's nothing written in the agreement, maybe it's been like 4 years and you didn't agree on the time frame.
Well, I haven't seen that happen, but
Okay, that's
typically,
good.
yeah, you have a long stop date. I mean,
Yeah.
you have professionals helping you with that space, so that will be
That's
addressed
good
in
to
some
know.
form.
Okay.
I mean, you could agree that whenever it happens, I will buy the company.
Okay.
I mean,
Yeah,
if you
but that
want
could be
to.
a bit unsure.
Yeah, a bit unsure. I would agree. So we have that covered, and then we have covenants, and that is things that should happen or that should not happen after closing, after the deal has gone through. And a typical one is that if you're the founder and you're selling the company to me, I will want a covenant saying that you will not do any competing business and you will not solicit any of the employees, any of the customers, or anybody else. So I will want to make sure that you stay put.
Okay, so not to start like a competitor or anything.
Exactly, because then I might not want to pay you 25 million. Because everybody is so connected to you, because then you might just start the same kind of business next door, right? And then we will move forward.
Yes.
To the really, 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 really important part for you to know is the reps and warranties. And those are typically the part of the agreement that you negotiate the most. Because that will be statements of fact that you as the seller will need to give about the company. And they will be lengthy. And if anything does not hold true, the buyer might come after you with a claim.
What can that be, for example?
Well, it can be that you say that all of the accountings is in order, that you paid all of your taxes on timely, that you have no lawsuits pending, that you have taken care of all the employment issues properly, that you have all of the IP protection that the company needs, that you own all of the intellectual property that the company needs. Because if you promise, you give a warrant about something, and then it turns out that no, we did not own all of the intellectual property we thought that you claimed that we did, I will come after you.
Yeah.
And then you have a lawsuit on your hand, and you don't want that.
No, so that's what can happen.
Yeah.
Okay.
So be mindful about the reps and warranties, and know that they can be absolute. Something is like this, point blank. Or they can be qualified. As far as I know, save as I have informed you or disclosed in the due diligence, everything is okay. And the latter, the qualified, is better for you as a seller.
Okay.
Because it's less room for me to come after you.
Okay.
Yeah.
Is there anything else that you need to think about doing this part?
Well, yeah, and that's connected to that, and I would say that's the final part we'll address here, and that's the limitation of liability.
Okay, tell me more about that.
Yeah, because you can, as a seller, you can say that, okay, I'll sign the reps and warranties, but you're this huge, huge big dog buying me, and I'm getting 25 million. So I want a limitation of liability for no more than the purchase price. So whatever happens, I know that you can never sue me for more than 25 million.
So you can decide on a price beforehand?
A limitation of liability. Or you can say that I want a limitation of liability for 10 million if you want to push it. I mean, anything really. You can limit the maximum liability.
Okay, and then if something happens in the company afterwards, then you have like a limitation. Is that what you mean?
Yeah. So even if you gave me a warrant and you said something and that was not true, you said that we owned all of our intellectual property, then the company gets sued for 100 million. But we have a limitation of liability on you for 10 million. Then I, as a buyer, can only come after you for 10 million. The other 90 million, that's on me. So that's why limitation of liability is so good. And also you can have it in time. So you can say, I give the reps and warranties, and you can come after me if something happens for 12 months or 24 months, but not after that. After that, I can sleep at night. Okay. And typically, some of the reps, we call them fundamentals. Those you cannot be as aggressive in your limitation. I mean, that you own the shares or that the company properly exists. Those you cannot limit typically. Okay. Or, I mean, if you've been fraudulent or something like that. No, okay. But just know and be mindful about the structure. And that's it. That's it. Now we're going to like the big part. Yeah. So, I mean, if I listen to this having a startup, I will feel very informed to take good decisions because it's a big decision selling a company. It's a big deal. Yeah. And all of these issues, I mean, we're happy to dwell into everything further and deeper. And that's why we're here, to give people opportunity to learn and spread the knowledge because knowledge is power. Hopefully. Good. Thank you so much. Thank you. But it's that big moment when the deal goes through. Welcome back. We reached the final step of all the 5 steps you need to know when you're about to sell your company. So, step 5. Now we're handing over the keys. What's happening now? Well, number 4, we signed the deal. We agreed. We agreed. And now it's time to complete the deal. Yes. The big day. The big day. Yeah. And most typically, still, you meet physically in a room and you have quite a few documents to sign. Quite a few things need to happen, like you need to replace the board of directors. You need to make sure that the share ledger is updated with the buyer. And of course, you need to do a wire transfer the money to the seller. Okay. At least in part. It can be that you have to wait if you're getting paid in tranches or through an earnout. But it's that big moment when the deal goes through, really. And everything signs over to the other part. Yeah. So it's the final step. Yeah. And often you will use the share purchase agreement because in that agreement you will have a list of everything that's supposed to happen on the closing. Like a checklist that you agreed on earlier. Precisely. And sometimes you have a closing binder, like an old binder that you go through step by step, make sure that everything's signed, everybody agrees, everything's handed over. So it can be quite old school. You can do it digitally, of course, if you want. But still, this is what will happen. Okay. So if everything is checked and then you can just hand over the keys. It's done. Exactly. It's quite big because, I mean, it's big to take over a company as a buyer. So you need to make sure you have access to all of the bank account. You need to be quite practical, really. So make sure to have a structure that you are sure that you have covered everything and then just do it. So you don't miss out on anything important. Precisely. Thank you. Thank you. That was the final part, number 5, the closing. If you have any more questions, please drop them down below in the comment section. And don't forget to subscribe and like. Thank you so much.